This is Bloomberg Law with June Grasso from Bloomberg Radio.
President Trump is turning to the Supreme Court over and over again as lower court judges rein in his efforts to push the limits of executive power. And the court's conservative majority seems to be accommodating him with consecutive but narrow wins, even as the liberal minority dissents, led by Justice Sonia Sotomayor, who expressed concerns for the rule of law at a Georgetown University forum last week.
One of the things that's troubling so many right now is many of the standards that are being changed right now were norms that governed officials into what was right and wrong. Once norms are broken, then you're shaking some of the foundation of the rule of law.
My guest is constitutional law expert David Super, a professor at Georgetown Law. David, if my calculations are correct, the Trump administration has made 8 emergency applications to the Supreme Court in less than 3 months. I'm sure that's a record, but why is the Supreme Court addressing so many of these issues?
Well, the Trump administration is making sweeping changes in our system of government, changing things that have been understood at least since the New Deal and many of them since the founding. So these are important enough issues to merit the Supreme Court's attention when they are enjoined for being unlawful.
So last Friday, the Supreme Court allowed the Education Department to withhold money for teacher training projects in 8 states. It was a 5-4 decision. Chief Justice John Roberts sided with the court's 3 liberals, indicating they would have denied the government's request. Do you see why he was with the court's liberals in that particular case?
Well, he didn't write an opinion, and he didn't sign the opinions written by the liberal justices. So my sense is that he simply didn't feel that the administration had made a sufficiently compelling case, and he wasn't entirely persuaded by what the conservative majority wrote in their opinion.
So did the conservative majority basically go off on a procedural point?
Yeah, many of these cases are procedural. The majority is looking with a very powerful magnifying glass at the procedure and in particular about which court something is filed in, and are in 3 of the most significant cases finding that they don't believe it was in the right court. That says nothing about the merits if the cases get refiled in the court that the Supreme Court prefers, which some of them already have been. So I don't think we can read very much into it other than that this court is hoping against hope that if they give the administration a little more time, that it will come into compliance with the law.
Justice Ketanji Brown Jackson, in a dissent, said it was beyond puzzling that a majority of justices conceive of the government's application as an emergency. I mean, it doesn't appear that there's a real emergency in most of these applications to the court.
No, it doesn't. There's no indication that funding these teacher training programs would do any devastating harm. But everything the administration does these days, it claims, is an emergency, and their basic theme is that they get to define what an emergency is, no matter how absurd that claim is. And for the moment, the Supreme Court is humoring them on this. My sense is that that game will only work for so long.
In probably the most high profile of these emergency petitions, on Monday the court allowed Trump to continue deporting Venezuelan migrants to prison in El Salvador under the Alien Enemies Act, granting an emergency request on a 5-4 vote without deciding if he was using that law lawfully.
Yes, they said that that case should not have been in the District of Columbia. It should have been in the Southern District of Texas. And the reasons for that are not silly, but not very compelling either. There certainly were plausible reasons to have filed the case where they did, but I think they're hoping that if they make the case start all over again in the Southern District of Texas, that the administration will chalk that up as a win and back off from its absurd policy.
They also didn't address the fact that hundreds of Venezuelan migrants have been shipped to El Salvador already and are in prison there, a harsh prison. And a Bloomberg News review found that just 7 out of the 238 migrants have been found guilty of serious crimes. I mean, they're sending people there based on tattoos and the kind of clothes they're wearing, and the court just let that go by?
Well, the court said that there wasn't jurisdiction in the District of Columbia, so they haven't said this is okay. They have instead insisted that all the T's be crossed and all the I's be dotted before a court takes action on this. Jurisdiction is one of the fundamental attributes of courts, and they do need to attend to their jurisdiction. On the other hand, past courts have been willing to resolve close questions on jurisdiction in favor of getting justice done. And here, 5 members of the court were not willing to do that.
Again, it was a 5-4, but this time Justice Amy Coney Barrett joined the liberal justices. Any accounting for sort of the Chief and Justice Barrett switching positions in these two cases? Do you see a reason for that?
I think that both cases, the majority's argument was tenuous, and it wasn't enough to persuade the chief in the first instance, and it wasn't enough to persuade Justice Barrett in the second instance. Both of them are signaling that they are not rubber stamps for the administration, but both of them, I think, are also signaling that they would like to give the administration a chance to come into compliance on its own. How long their patience will last remains to be seen.
Then on Tuesday, in the first mass firing case to reach the court, the justices bolstered Trump's campaign to fire federal workers, blocking a judge's order that required the administration to reinstate employees. So this was 7-2 with Justices Sonia Sotomayor and Ketanji Brown Jackson dissenting. Again, based on procedure?
Yes. The argument was that these cases should have been brought initially through the Merit System's civil service process and resolved there rather than in federal court. If there had been one individual person fired based on a quibble over whether they were taking too much sick leave, absolutely the Merit System's process would be the right place. When it's being done as a matter of policy on a mass basis without any consideration of individual circumstances, an injunction seems more appropriate. But here, the court decided to, again, insist on jurisdictional perfection.
Is the majority sort of taking the easy way out in these cases by making it more about procedure than about the merits or the administration's policies?
Oh, yes, very much so. You're not seeing opinions endorsing what the administration has done. That would be very easy for them to write, either as an opinion of the court or as a concurring opinion from Justice Alito or whomever, and you're just not seeing that. You're seeing nitpicking on jurisdiction. So no one is sending the administration signs that what it's doing is okay. And I think if the administration's lawyers are paying the least bit of attention, they will recognize that they're being given time, but absolutely no encouragement on the merits. And once the plaintiffs follow the instructions of the court as to how to obtain jurisdiction, the court is giving the administration no encouragement that it will get support on the merits.
Yesterday, after a decision by the entire D.C. Circuit to reinstate 2 independent agency officials fired by Trump without cause, Trump went to the Supreme Court, and the Chief Justice issued an order putting the Federal Appeals Court decision on hold, so the fired workers remain fired. Does Roberts' action indicate support for Trump's efforts to remove any limits on his power to hire and fire?
That's not clear. The Chief Justice has previously stayed actions of lower courts and then turned around and voted against the administration on the merits. So at the moment, all we can assume is that this stay is an indication that he thinks that all the justices ought to be able to weigh in, which is sensible enough on an issue of this scale. On the other hand, the question of independent agencies may be a more complicated one in the court because several justices have indicated that they don't like independent agencies or don't believe that their independence is appropriate. So on this one, it certainly is possible that when all is said and done, the administration will succeed in changing constitutional law. I don't like the administration's chances on most of the others.
Really? So you think that in this one, the justices will expand presidential power even further?
I think it's possible. There are justices who have said that the old Humphreys executor case, that is the foundation for independent agencies, was badly decided and should be rejected. We don't know how most of the court will rule. I think it's very possible that some of the justices will feel that this is not the time to do away with agencies' independence when you have a president who is hyper-partisan and pursuing an agenda with apparently very little consultation with lawyers. But it may be that they will take this as an occasion to make the ruling that they've hinted at and get rid of the independence of these agencies.
Does it seem like there are 4 solid votes to allow Trump to do whatever he wants?
No, I don't think there are. I think if there were, you would see them writing concurrences endorsing what the administration is doing on the merits. I think the justices sitting now are all serious people. They're people who I disagree with on a great many issues, but I think that they have to be concerned with the threat to the rule of law here, and their silence on the merits could indicate that they're hoping the administration will understand it can't overplay its hand.
The administration keeps taking bows, saying it's winning. It's winning at the Supreme Court. So even though
if their lawyers are any good, they're telling them behind the scenes that you're dodging a bullet here and dodging a bullet there, but that the silence of even the most conservative justices on the merits of your action is quite deafening.
Even if these wins are temporary and procedural, aren't they backing Trump's actions to transform the federal government, allowing him to go forward? At least in the public's mind, that's what they're seeing.
Oh, certainly. The public's perception, this looks like Trump is winning. And until we get a case that doesn't have the procedural glitches that the cases getting to the court so far have had, we won't know for sure how the justices will break out on the merits of this. The fact that they can't hold a consistent 5 should be a warning sign for the administration, but we won't know until we get actual decisions. When the administration shows that it is utterly unwilling to listen to these hints from the Supreme Court and follow the orders from the lower court, we will get a much clearer decision where the justices all write on the merits of some important issue, and we find out where it all stands.
We'll see how long it actually takes them to get to the merits of a case. Great having you on, David. Thanks so much. That's Professor David Super of Georgetown Law. Coming up next, crypto enforcement is dying down. This is Bloomberg. The Justice Department is disbanding its crypto enforcement team and scaling back on enforcement in line with President Trump's directives. Joining me is an expert in financial market regulation, Yesha Yadav, a professor at Vanderbilt University Law School. The Justice Department has shut down this unit that investigates cryptocurrency fraud effective immediately. In a memo, Deputy Attorney General Todd Blanche said, quote, "The prior administration used the Justice Department to pursue a reckless strategy of regulation by prosecution, which was ill-conceived and poorly executed." Why are they doing this, really?
Well, June, it's a very interesting question because what we have here is a cryptocurrency enforcement team that I think was really the envy of the world in many ways. What this team brought together was a deep amount of interdisciplinary expertise and intelligence across the Justice Department, which had proven itself as being extremely effective at marshaling technical expertise, at coordinating amongst different groups, at developing a strategy for pursuing some of the most aggressive bad actors in the cryptocurrency economy, most particularly like, for example, the North Koreans or relentless hackers. One of the most successful cases of this team was really the Bitfinex hack, in which they prosecuted Ilya Lichtenstein and the famous rapper Razzle Khan, infamous rapper in some ways, and collected a great deal of stolen crypto as a result of this. They pursued dark markets. And what that has shown is that the Justice Department, through this team, as well as other personnel, obviously, are extremely adept at keeping up with some of the technical innovations, the creativity, the cat and mouse chase that the technology enables. And this team was bringing that expertise together to do that. You know, what this enabled was making sure that the prosecutions that were coming up to hold bad actors accountable had the evidence that they needed to back them up, had the technical know-how to ensure that standards of liability would be met through the evidence of what was really happening. And so this team did a lot from that perspective. And so it'll be interesting to see what happens next in terms of how that expertise, as it diffuses across the Justice Department, can be marshaled still to prosecute the bad actors in the crypto economy.
I mean, are they interested in pursuing the bad actors? The Securities and Exchange Commission has also dismissed lawsuits and pending investigations involving crypto firms.
The memo, what it said was essentially that the financial regulators would play the lead role in taking into account the regulatory failures that are happening in the crypto economy, and that the Justice Department would be less aggressive in this regard. You know, what's interesting at this point is that the regulatory framework for crypto is still being built. For example, Congress is working on a number of pieces of legislation to create that regulatory perimeter to define exactly who gets to regulate particular kinds of assets, how they're going to do it, what kind of particular provisions need to be put in place. So, for example, right now, you know, one of the major pieces of legislation involves stablecoins. This is a kind of crypto asset that is very, very popular and impactful for payments. And what that means when it's, you know, for something like payments is that aspects like money laundering, aspects like, you know, knowing people's identity and how to make sure that bad actors are not implicated, you know, these things become involved. But at present, these frameworks are really not there to the same extent. And so the financial regulators, for example, as you noted, the SEC has said, for example, that they won't regulate meme coins. This is an area of the crypto economy that has been perceived as being quite seedy, where allegations of pump and dumps have been rife. And so the SEC at that point says this is not their jurisdiction. Other regulators like the CFPB, the Consumer Financial Protection Bureau, have seen a great deal of sort of legal dismantling about their apparatus. And so the question really is, who's going to police the bad actors here? And, you know, in the case of the Justice Department, they have not been bringing claims with respect to, for example, whether or not crypto assets are securities, whether they're certain kinds of commodities. That's not the Justice Department's business. That's not what they're doing. What they've been doing is prosecuting cases that involve criminal activity, very much on their beat, such as money laundering, terrorist financing, fraud. And so the question becomes really, how are these kinds of bad, you know, illicit activities going to be dealt with going forward? You know, one last thing just to say on this is that the need to protect the crypto market, the need to ensure it's clean, the need to make sure that it's perceived as being immaculate and trustworthy is something that many in the industry want themselves. They want to see this industry as being one that people can trust, particularly after meme coin scams, FTX, Sam Bankman-Fried, and, you know, Celsius and other, you know, various hacks that have happened. You know, the industry itself wants to be seen as, you know, as one that's worthy of trust. And so the Justice Department's played a big role in that. Certainly not perfect. There have been lots of instances where it's been criticized for certain cases. But broadly, by and large, they've shown themselves as being extremely intelligent and adept at doing the job that they've done.
So you mentioned Sam Bankman-Fried. Would a case like his go under the radar without this unit in place and with the new emphasis at the Justice Department?
Well, the memo did say that they would be pursuing hacks, that they'd be pursuing illicit activities connected with crypto, for example, things like human trafficking. The memo also mentioned, the potential for kind of DeFi protocols that may be facilitating cleaning post a kind of hack, that these would also be pursued. So it's certainly not ruling out prosecutions for cryptocurrency-related criminal activity. What the dismantling of this unit, however, potentially could lead to is difficulties in creating the evidentiary trails, in keeping track of where the vulnerabilities are with respect to the hackers having a leg up in terms of technical advantage and speed and the capacity to innovate, and the government not having the ability then to keep up with these developments. And so, one of the things that was interesting in the Bitfinex hack, for example, and the prosecutions of Ilya Lichtenstein and Razal Khan, was that the government's affidavit showed that they were incredibly good at following really complicated transaction trails where money was being filtered through numerous blockchains and using, various kinds of different marketplaces, darknets, to kind of clean the cash. And so these are evidentiary intelligence that this unit was able to create. And similarly for Sam Bankman-Fried and other sort of major large-scale wrongdoers that are very sophisticated potentially at moving crypto, at hiding their evidence of their transactions. Even though the blockchain is transparent, one can use all sorts of different protocols to try and, maybe clean the money very quickly, as it happened with respect to the North Korean Bybit hack. And so, these are things that this unit was good at. And so it's not that the prosecutions are not likely to happen. I'm sure that, the Justice Department will do what the Justice Department does. But at the same time, it's about being able to collate that in evidence, to be able to get ahead of the technology, to be able to predict where some of the bad actors might go next, and then prepare the government to make those prosecutions really stick.
Do you think there'll be an increase in state regulatory activity? Last month, California's AG said it would continue protecting consumers from crypto confidence scams, and AGs in New York, Massachusetts, and Illinois said similar things. You think we'll see more enforcement on the state level?
Absolutely. So I think the states are definitely revving up to step into some of the gaps that may be left here. One has seen states in general over the last couple of years as, crypto has been gaining a foothold in the mainstream. States have stepped up in any event to try and regulate this marketplace. So some notable examples here include New York and Wyoming, for example, that have put, perimeters in place for crypto activities. And so with respect to just general wrongdoing in crypto, certainly one is going to see the states step up. As you mentioned, California, New York, and others, I'm sure, will be paying close attention. In addition, of course, one aspect that does need to be addressed here is that certain crimes are federal crimes, which do require federal intervention. So when one thinks of money laundering, terrorist financing, wire fraud, these are cases that are being brought federally as federal crimes. Often these can carry higher penalties and therefore potentially have, a steeper deterrence effect. And so the question really becomes, does the lack of federal emphasis here mean that certain kinds of offenses, such as money laundering, terrorist financing, fail to get the intensity of prosecution that they have currently, and what will be the effect of that on, bad actors in this economy potentially taking advantage of the U.S., which has been the cop on the block worldwide, not just here in the U.S., of the Justice Department potentially taking its foot off the pedal with respect to the aggressiveness with which it pursues these claims.
I mean, do you think this sort of let up in crypto enforcement is because Trump wants to make this the crypto capital of the planet? Do they see less enforcement as part of that goal?
I think one of the aspects here that was indicated in the memo itself is a reaction to the perception that the last administration was very aggressive in using litigation as a strategy for creating a regulatory perimeter for crypto. So in general, there has been a lot of criticism of regulation by enforcement, trying to make cryptocurrency fit existing rules through litigation, through bringing lawsuits, rather than creating rules and creating a perimeter through a conversation with the industry rather than just litigating against the industry. So, it feels like that this memo seems to be a kind of reflecting a backlash to that approach. One of the aspects that the memo sort of singles out is that it speaks to the perception that some of the cases that were brought by the Justice Department, for example, against Tornado Cash, against developers in this space, were ones that were overly aggressive, were ones that, overstepped the bounds of what the Justice Department should be doing. In particular, just to give you some background, the Justice Department brought a case against a number of developers, those who write the code. They were bringing cases against developers of mixers. These were codes that can potentially create a greater degree of obfuscation between who owns the crypto and the kind of transaction trails that might exist there. And for the developers, these were privacy-enhancing code. These are privacy-enhancing tools. And furthermore, writing code, they have argued is a free speech right. And so prosecuting it led to a great deal of criticism against the Justice Department from the industry. And so part of this memo appears to reflect that feeling that developers, that those who are writing code, that those who are creating in this space were potentially being targeted in ways that were unfair. But, equally, the question then becomes what happens when, the entire enforcement approach is geared towards scaling back, especially when the industry is now becoming mainstream, when everyday users are looking to get into crypto in a big way, when it's being encouraged as a very mainstream activity for Americans by an administration that's really backing this industry. And the industry is coming into its own at this point.
It seems like something may fall through the cracks. Thanks so much for being on the show. That's Professor Yesha Yadav of Vanderbilt University Law School. Coming up next, Trump cuts labor mediators from 143 down to 4. This is Bloomberg. The Federal Mediation and Conciliation Service is a small labor agency that has played an outsized role in some of the nation's largest workplace negotiations over the last several years, including those at Starbucks, Boeing, and Apple. But now the Trump administration has gutted the FMCS of nearly all its labor mediators, endangering a key means of resolving employer-union conflicts, driving up negotiation costs, and potentially leading to more strikes and lockouts. Joining me is Bloomberg Law reporter Parker Purifoy. Parker, tell us about the Federal Mediation and Conciliation Service.
It was, kind of a small agency, and its main role was to provide mediators to employers and unions. They do both public sector and private sector work. So they send mediators in when there's some kind of dispute over a, contract or a grievance or something like that. They'll try to get the parties both on the same page.
There are 143 mediators before Trump took office. How many are there now?
There are 4 left now, from what we can tell from speaking to employees there. The administration gave various offers for early retirement incentives or other, more buyout structured incentives to leave. So we know that some of the mediators took those incentives to leave the administration, and then the rest after that were laid off. So they're on administrative leave right now, and then they'll be kind of rolled into the reduction in force procedures and laid off.
Explain how the mediation service has been crucial in preventing and ending strikes in recent years. Tell us about some instances.
Yeah, I always say that they kind of fly under the radar because no one really talks about them. Reporters don't talk to them, they're not quoted in any of these big stories, but they are on hand a lot in these, really big labor disputes. So one example was the strike between Boeing and their machinists last year. The FMCS mediators were on hand for that. And also, as I'm sure you can recall, there's been some contract disputes with the dock workers in East and West Coast ports over the last couple of years. And the mediators were also on hand during that. Another example is that they helped facilitate a first contract between Apple and some of its retail workers up in Towson, Maryland last year as well. In 2023, they helped negotiate almost 2,500 collective bargaining negotiations, so they're involved in quite a lot of them.
Jefferson Diedrich, an FMCS commissioner, said in March 26th post that it saved the economy over $500 million annually with less than 150 mediators and 0.0014% of the federal budget. So this was a tiny agency comparatively.
Right. I think its budget was somewhere in the ballpark of $50 to $70 million. So really tiny compared to, most of the other agencies. But as Jefferson said in his post, they certainly have kind of an outsized impact on the economy when you think about all of the work that they do to prevent strikes that could be, crippling to the economy.
Has the effect of this been felt yet?
Yeah, definitely. I actually spoke to a number of attorneys, mostly in the private sector, who said that they found out about the layoffs because the mediators that they were working with in their, current negotiations had to leave the bargaining table because they were told that they were laid off. One concrete example is Starbucks, and Starbucks Workers United has been involved in kind of a month-long negotiation process to try to come up with a framework for bargaining their contracts, and their negotiations were being mediated by FMCS mediators, and one of the two of their mediators were laid off and pulled off of the table. But I think that more than that, I have heard a lot of anxiety amongst attorneys in the last couple of weeks who say that now they're going to have to look to getting private mediators, and they're going to have to split the costs. The employer and the union are going to have to split the costs of the mediators, and so all of this is just going to drive up the cost of negotiations and also bring in more potential for strikes or lockouts or other eventualities like that.
What happens in the public sector where some federal and state agencies are contractually required to mediate through FMCS? So what would happen there?
Yeah, I think it's pretty fact-specific, but like you said, a lot of state and federal agencies have to involve an FMCS mediator somewhere in their process before they can go to either arbitration over a dispute, or in the federal sector when a union is trying to negotiate a contract and they're having a difficult time reaching an agreement with the government, the mediator will step in, try to mediate that dispute. If the mediator can't, help them reach an agreement, then the mediator needs to sign off in order for the dispute to go before a panel who will ultimately decide what the terms of the agreement are. So this is kind of just placing, I would say, even more significant roadblocks for the public sector because they are contractually obligated to seek the approval of FMCS mediators, and now that could potentially take months or years to do that, now that there are only 4 mediators available for the whole country.
Can other agencies within the federal government fill in the gaps, like the NLRB?
So the NLRB legally cannot use any of their money that's been appropriated by Congress to pay for mediation services. A lot of times the NLRB will help connect parties to FMCS, but the NLRB cannot do that themselves. The Labor Department has been involved a little bit. Labor Department officials will frequently, get involved in some of these higher profile strikes or contract disputes. Like under the Biden administration, Acting Labor Secretary Julie Su would go out to negotiations pretty frequently to help negotiate. But, I think taking up all of the work that FMCS and just folding it into the Labor Department, what I've heard from sources is that is not a feasible option at this point.
A coalition of 21 states sued the Trump administration last week over laying off staff and reducing the functions of 7 federal agencies, including the FMCS. What are the grounds for that lawsuit?
The states are basically alleging that the actions by the administration are having adverse impact on the states. So the states do mention, in regard to the FMCS, they mention that a lot of their state agencies need to go through FMCS, and if they were to have to engage with private mediators, that would place a large financial burden on the states to do so. And yeah, they're basically alleging that these agencies, not just FMCS, but these other small agencies, were created by acts of Congress, and they believe that the president can't just unilaterally essentially get rid of them.
Is the FMCS just one agency among many that has been targeted, or do people say that it's been targeted because it has to do with labor and labor unions, which the Trump administration has also targeted?
Mm-hmm. I mean, I think, the federal government is seeing pretty unprecedented level of layoffs. Certainly, Trump has stated and has indicated that he is willing to do everything that he can to, reduce what he says is administrative bloat and fraud and wasting of taxpayer dollars. But certainly FMCS is only one of the labor agencies that has been impacted. Trump also fired one of the NLRB members right at the beginning of his term, along with members of other agencies that resolve disputes within the federal government. So certainly many of the labor side attorneys that I talked to say that this is a deliberate targeting of the labor agencies in order to kind of remove workers' paths towards getting recourse, in any of these actions.
According to an agency fact sheet, FMCS was involved in 2,467 collective bargaining negotiations, 1,265 high-impact grievance mediations, and conducted 1,566 training programs in 2023. Thanks so much, Parker. That's Bloomberg Law reporter Parker Purifoy. In other legal news, at the Justice Department, where Attorney General Pam Bondi's tenure has coincided with the removal or reassignment of a growing number of career officials. According to Bloomberg sources, the Justice Department removed the acting national security head from his post hours after Bondi saw a portrait of former President Joe Biden continuing to hang in the division's front office. This happened in February, just weeks after Devin DeBacker was elevated to serve as the acting chief of the National Security Division. He's a former associate White House counsel during the first Trump administration. His demotion came the same day Bondi saw the portraits of Biden, former Vice President Kamala Harris, and former Attorney General Merrick Garland still on the wall. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.